Hello, so today Pamela, Alfonso, Irache, Dana, Maria, and myself, Julie, will be presenting the Charter of Fundamental Rights. So here's a quick overview of what we'll be looking at, but before diving into the more detailed affairs, I will be giving you like a brief introduction on what the Charter of Fundamental Rights actually is. So it basically sets out various civil, political, economic, and social rights. Now, there is a lot of overlap, or like could be seen like a lot of overlap within between the Charter of Fundamental Rights and the Human Rights Charter. But the difference is that the Fundamental Rights Charter is used in the European Union to express the concept of human rights, but within the specific EU internal context, while human rights are mostly used within an international law.
As explained briefly, the EU Charter of Fundamental Rights brings together the rights enjoyed by the people in the EU. Moreover, it strengthens the protection of fundamental rights by making them more explicit for citizens. Democratic rights, such as the right to vote, to stand as a candidate in the elections, freedom of assembly and association, are all set out in the Charter. Among them is Article 31, which expresses and lays out the fair and just working conditions for workers. Article 31, Section 1 says that every worker has the right to working conditions with respect to his or her health, safety, and dignity. And Article 2 expresses that every worker has the right to limitation of maximum working hours to daily, weekly rest period and to an annual period of paid leave. Interesting to note that citizens can invoke the Charter's rights before the national courts, and the Charter is binding for all EU institutions and for national authorities when implementing EU law. The concepts of freedom, equality, solidarity, justice, and citizens' rights are all core values of this Charter that can also be seen in Article 31.
So now I will talk about Directive 89/391/EEC. So what does it cover? This directive of the 12th of June of 1989 introduced measures to encourage improvement in the safety and health of workers at work. The scope of this directive is the following, and it is under Article 2. It does apply to all sectors of the activity, both public and private sectors, but does not apply to certain public services that meet peculiar characteristics, such as the police or the armed forces, or certain activities in the civil protection services. Some general content of the directive. We have to know that member states are subject to the legal provisions of this directive. Also, as this directive is related to the labor force, some definitions have to be clear, like what is a worker, what is an employer, workers' representative. And also, as this directive is specifically about safety and health, we have to know what prevention is. All of this is under Article 3. Bear in mind that not only employers have obligations and responsibilities, but workers. And now we'll talk about some employers versus workers' duties. So for example, under Article 6, employers have a duty to ensure the safety and health of workers in every aspect related to work. This means taking the necessary measures, such as training, provisional information, prevention of occupational risks, and others. Also, we have to know that this will change according to the circumstances not only of the company itself, but of the country. So for example, with the pandemic of COVID-19, they had to be changed. Employers also have to designate 1 or 2 people to carry out this type of activities. And last but not least, employers shall consult workers and allow them to take part in the discussions on all questions related to safety and health. This will ensure that workers feel part of the community and they are heard. And now, some workers' duties, so they have the responsibility to take care of their own safety and health. This means making correct use of machinery and the equipment they are given. Also, they have to inform as soon as they can to the employer of any possible danger to the safety and health of not only themselves, but also of the other co-workers. And now I will move on to give the word to my colleague that will talk about the social charter. Thank you.
Hi, my name is Alfonso, and today I'm going to tell you about the Social Charter, also known as the Social Constitution of Europe, which is a treaty from the European Council that guarantees fundamental social and economic rights. It is 100% complementary to the European Convention on Human Rights. Both of them are based on the same principles of universality, indivisibility, and interdependence. The Charter guarantees a broad range of everyday human rights, such as employment, which is what we're seeing here, safety at work, health, social protection, welfare, housing, or education. Also, the Charter lays a specific emphasis in the protection of vulnerable persons, such as the elderly, children, persons with disabilities, or migrants, for example. The Social Charter requires the enjoyment of these rights must be guaranteed by all states without discrimination of any of the citizens, well, persons, individuals that we stated before. The well functioning of the Charter is examined and analyzed by the European Committee of Social Rights by analyzing complaints and reports given to them, usually by social partners or non-governmental organizations. As you can see, the Social Constitution of Europe plays a very important role in securing and enforcing the social rights of the citizens of the Union. So that's all we have for Social Charter. Now I'm going to let my colleague talk about the next issue in this presentation. Thank you.
When we talk about labor law and labor rights in the European Union, it's crucial to mention Community Charter of the Fundamental Social Rights of Workers. This charter was agreed upon on the Strasbourg 9th of December, in Strasbourg on the 9th of December 1989, and it's basically granting the treaty of the European Union, the community, the powers to regulate areas such as freedom of movement of workers, the right of establishment, freedom of establishment, improving health and safety working conditions, as well as the equal pay and women for equal work. As we know, the European Union law in certain areas has the supremacy over the national law of the countries that are members of the European Union state. So if European Union is given a competence, a primary competence to regulate and such area as, let's say, working conditions, which they were given at the Strasbourg Treaty due to its close link with this efficiency of the internal market of the European Union. The laws that European Union would implement across all of the European Union through directives or regulations would effectively be primary and above national legislation, affecting both nationals of the European Union and legitimate residents who have the residency permit, allowing them the freedom of movement and safely guaranteeing them the high working conditions and quality working conditions that would allow them to perform their functions.
Okay, so now I'm going to talk about the Directive 93/104, the so-called the Working Time Directive. So the Working Time Directive was introduced in 1993 as a health and safety measure, as a practical contribution towards creating the social dimension of the internal market of the EU. Its main objective is to adopt minimum requirements covering certain aspects of the organization of working time and working rights connecting to the workers' health and safety. Its scope initially, it covered all sectors of activity except transport, activities at sea, and the activities of doctors undergoing training. But since the amendment of June 2000, when the new directive was introduced, workers belonging to these three categories, to transport, activities at sea, and activities of doctors undergoing training, have been covered. And there are certain provisions specifically for these type of workers. So now I'm going to talk about the contents of the directive. The directive provides for a working limit of 48 hours over 7 days, averaged over a reference period of not exceeding 4 months. The directive also provides for night work limits, health assessments for night workers, and entitlements to weekly, daily, and in-work rest breaks and 4 weeks paid annual leave. So workers are provided with sufficient compensation for their working time. So as said before, there is a new directive, Directive 2034, and it amends the previous Directive 93/104. The new directive adds the terms adequate rest and mobile worker. The latter term refers to any worker employed as a member of traveling or flying personnel by an undertaking which operates transport services for passengers or goods by road, air, or inland waterway. And the Directive 2034 also introduces a new term called offshore work. This work is generally performed mainly on or from offshore installations. So as to workers' rights, according to Directive 2034, members shall take measures to ensure that workers enjoy the minimum daily rest period of 11 consecutive hours, the minimum period of one rest day on average, immediately following the daily rest period in every 7-day period, which allows the workers to rest for a sufficient period of time. The directive also allows workers to enjoy a daily period of work of more, if they're employed for more than 6 hours a day, they are allowed to enjoy a break as defined by the provisions of the collective agreements concluded between social partners or national legislation. The directive also ensures that the workers enjoy not less than 4 weeks annual paid holiday, qualification for which shall be determined by reference to national practice legislation. So it basically allows the member states to determine the national legislation as to the period of time of their annual paid holiday. And lastly, the directive also provides for an average weekly working period of not more than 48 hours, including the overtime for each 7-day period, basically making sure that the workers don't overwork, and if they do, they get a paid leave.